Let me first start by introducing us. Laurie Meyer, who you can see on video, and I both work for Davis and Kuelthau. We're a smallish, medium-sized law firm with offices in Milwaukee, Green Bay, and in Brookfield. Laurie focuses her practice on employment law and different aspects of employment law, while I do some employment law in the litigation field. My focus is on litigation, general commercial litigation, as well as a few other things. So we appreciate your coming and attending. Laurie's put up the screen which shows the link to get the presentation materials. With those materials, we don't have a lot of slides, you'll see. We do have some fact situations that we're going through, but we also have the outline for today's presentation as well as links to a couple of articles, one that Laurie wrote, one that I wrote, dealing with business liability considerations.
Oops, sorry. There you go.
Yeah, so that we can, we'll get to that fact pattern. What we're going to do is we're going to do the presentation really in two parts. I want to talk about liability, perhaps liability in general, and then specific to maybe business liability, and we'll walk through this fact pattern that Laurie has on the screen. And Laurie's going to talk about liability for employers. So I'm looking more at the workplace and general liability to people who are not employees or doesn't rise through your employees. Laurie's going to talk about employment. So let's talk first about what creates liability, and I'm going to talk about this specific to the business setting as opposed to individual setting, but the principles are the same. You can have liability that's created by the legislature, by statute, or by ordinance, or by code, or you can have liability that's created by case law and by sorry, I'm looking at the, I got distracted by the video. So you can have liability that's created just by case law and what the courts have decided. And in general, if you're looking at liability that's created by what's called common law, the general principle is that people and entities owe others a duty to use ordinary care under the circumstances. What that means for businesses is a business may be subject to liability for physical harm or damage that's sustained by frequenters, people that are on the business premises, if the business knows of or by the exercise of reasonable care would discover a condition within the premises that is dangerous. And the business entity then fails to take reasonable care to protect people who are on the premises against that danger. So if there's a violation of that duty and that violation causes harm, then the business may sustain liability. So let's talk specifically about some of the business considerations. We heard from Greg Marcus and from Tim Michaels the types of business they have, two really different businesses in terms of what type of business and how they run their businesses. But the principles remain the same. What might be different is if there is how many people are present on the premises, who's invited on the premises. So let's talk about a business that has limited visitors. We have, for example, in our office, while we do on occasion have clients come into the office, especially since the pandemic, our offices are closed, they're locked. You have to have someone escort you up to the floor on the 14th floor in Milwaukee, and you have to have someone come bring you in within closed doors. So we do have some vendors. We have UPS delivers and FedEx delivers. We have some clients, but for the most part, we're a closed company. Compare that to Greg Marcus's example, where his business really thrives and depends upon people coming and being present. And so for someone who is inviting the general public in, you have to not only take care that you're protecting your employees, but your duty to use reasonable care is going to extend beyond your employees into everybody who is on your premises, and knowing that you're bringing people on your premises, that you're depending on people on being on your premises. You have to look very closely at what that means. So let's look at this first fact pattern that Laurie has up. I'll run through it quickly. I think you can all read it, but I will run through it quickly. A large grocery store chain provides an essential service and was able to remain open during the safer at home, during the shutdown, and during the pandemic. Of course, the store owners were relieved. The store owners would be bringing in revenue, while many of the businesses were closed or operating on a limited scale. Management put a policy in place where they were following the CDC guidelines, requiring social distancing among its employees and customers. Even before the mask mandate that's present in some of our counties, they required the use of masks when inside the business, erected plexiglass barriers, cleaned the carts, the baskets. So they were pleased, they had customers, people were coming in. They felt they'd really weathered the storm, until one day, store confirmed that 18 of its employees tested positive for COVID-19. An additional 65 employees were sent home to quarantine. That, of course, triggered an investigation. And what the investigation revealed was that there had actually been complaints by employees to the supervisors that policy that management put in place wasn't being followed. So where do we have, what creates the liability? Well, what creates the duty is the fact that this business is open to the public and is inviting employees to come in and work and inviting customers to come in and shop. So the business has a duty to use ordinary care to protect all of those people. What is ordinary care under the circumstances? So the management did the right thing. They put in place a policy. They were trying to follow the CDC guidelines, and they put forth all of these measures. Where this business in this fact pattern fell down is that while management had a written policy, they didn't follow it. So it's not enough to have a policy. You have to follow that policy and make sure your employees are following that policy and the customers are following the policy. Now, Laurie's going to talk about the employment aspect. We'll use a different fact pattern with when
Sure.
Laurie talks about employment. I'm not going to address the liability that the store may or may not have to its employees who tested positive. But now let's think about the people that were shopping at this grocery store. So many of these people, this was their only outing. They stayed home. They didn't go out. They went to the grocery store only because they were assured that all of these measures were taking place. And now the employees at the store have tested positive. So for the customers, if the customers then end up being, customers need to be notified, and if the customers test positive, there is the possibility that the customers are going to say, I can trace this positive test, this fact that I now have the COVID-19, I can trace it to my exposure at this grocery store because it's the only place I've ever gone. Under those circumstances, there is the possibility that the store, particularly the store that didn't follow the policy that was in place, would bear some responsibility and liability exposure to those customers. and I don't want to take too much time to talk about this. There's a funny hybrid situation where, as I said, Laurie's going to talk about the responsibility to the employees, but what if the employees come home and now their family members test positive? So there's those considerations that need to be taken into account as well. One last thing before I turn things over to Laurie. I mentioned in the very beginning, I mentioned some statutes or code liability. This particular fact situation also takes into account that if the employees or customers complained to OSHA, this store might also have liability to OSHA for failing to follow the CDC guidelines. So that's sort of a nutshell about business exposure, not dealing with employees. Laurie, anything to add?
Yeah, the only thing I would add on the employment aspect of this fact pattern is, one, you might have triggered, it's very likely that the FFCRA, Families First Coronavirus Response Act, which is the emergency paid sick leave, and the expanded FMLA, that might have been triggered by the fact that if in fact a quarantine order is issued by the health department or anything like that with regard to all of these employees, then it's not that they're quarantining at their own of their own volition, but the 18 tested positive certainly triggered it. The others might have triggered it under point 1 under FFCRA. So you might be aware of that. And then as to Kathy mentioned about being careful of retaliation, you've got NLRB issues, you've got certainly OSHA retaliation, anything like that. So employers are well advised to be careful of retaliation possibilities, because that can bring about another claim. Okay, I don't know why my thing is not moving now. Oh, oopsie, whoopsie. All right, so we're going to move on to the second fact pattern. And this fact pattern is something that really comes up quite a bit in my experience. As Kathy mentioned, I work exclusively in the area of employment law representing management. And this is coming up quite a bit. This is as, folks are coming back to work, in this circumstance, an employer, and it can really be anybody, it can be somebody who's public facing or not. Some folks have been furloughed, maybe they've been teleworking, but in any event, they have not come back physically to the office, to the workplace, wherever it might be. And when the employer says, good news, we're returning, you have employees who don't want to do that for whatever reason. My advice from an employment lawyer standpoint is really an employer is courting danger if they make a blanket rule, everybody comes back as of August 1 or whatever it might be, no matter what. What you have to do is, if you get employees balking at that, you have to drill down and you have to ask why. Those are because there's certain duties that every employer has, especially in connection with the Americans with Disabilities Act and its counterpart in Wisconsin called the Wisconsin Fair Employment Act. And that requires duties to accommodate certain disabilities. And that is really triggered by that second reason I have here. I have a serious heart condition, or it could be, any number of things, where a doctor has said, you shouldn't go back to work in this scenario because that doctor considers me immunocompromised. In that scenario, the employer's duty is to investigate whether or not can the employer accommodate telework or an extended medical leave or something like that. Is there something, and this requires usually, probably with the help of experienced human resources and experienced employment counsel, investigating further with the doctor, are there things we can do? Let's say the person cannot telework because that's not their job, and telework is really not something that's feasible. Or maybe, if they're teleworking, they're only getting half their work done. So making a telework really converts their job to a part-time job, something like that. Is there something we can do? Can we put the person in a kind of an isolated area? There are different barriers and things that can be erected. All those things can be investigated. But what you can't do is say, we're not going to investigate at all. Maybe it's the case that what you do is an unpaid medical leave, and that's entirely possible. Assuming that they're FFCRA. Oh, hello, Kathy. You've appeared.
Hello.
Yeah, maybe it is the case that if they're FFCRA leave, their paid piece of that is it has been exhausted, that what you're talking about is an extended medical leave where they aren't paid, and maybe that's just what it is. But what you can't do is have a across-the-board rule without an interactive process, because that will come back to haunt you. Another reason, the first one, is I make more money on unemployment right now. $600 is set to, the extra kicker under the CARES Act is set to expire on July 31st. There's a lot of talk about that being extended, but that's certainly an issue. Generally speaking, that is not a, quote, protected reason under the law. That I make more money on unemployment right now, I can't give that up, is not something that protects the person's job. So you have to investigate and figure out what the reason is. And then the last one, it really comes up quite a bit, especially with older employees or people who might not have been, or maybe they have a family member who is immunocompromised, they aren't themselves. And there's just a generalized fear. Maybe no doctor has told them to stay at home, but they're just saying, I'm not going to do that. In that scenario, your best advice is to talk to the employee, just as most employers would do, and assure them at what kind of steps you're taking in terms of to protect your workforce, and to make sure that they can understand that. But again, that is not usually a protected reason under the law that would protect a person's job. On the flip side of that one, I would hesitate. I would certainly advise against any employer saying, we're going to bring back people in phases, and we're just going to take everybody over 60 or everybody over 55 or something like that and put them in third phase. You can't make assumptions about people's health conditions or age or anything like that. It's one thing when an employee has come to you. It's another thing when you make blanket situations or blanket rules.
Well, and so one of the reasons, just to expand on what Laurie's saying, is one of the reasons that you can't just say everyone over 65 is going to be in the third phase. It is because you are risking some discrimination.
Sure.
To claim that was discrimination, and that person who is over 65 wants to return to work, doesn't feel that they are compromised in their health by any reason. Well, it looks like we're closing up here.
Yeah. Okay.
So there is a concern there. Sorry, Laurie.
That's okay. The last one, the last issue has to do with folks who have been teleworking just fine, but the FFCRA, one of the key things, and I'll just say this very quickly, is in order to be eligible for expanded FMLA leave, a person has to be unable to work or telework. If they have been accomplishing that just fine for some time, it's going to be, the employee is going to be hard pressed to say, because in this, and I'm trying to hurry through this, in this instance, the employer has been accommodating, you can do this work at 2 a.m. if you want. So if that's the case, then they're going to be hard pressed to say that they can't telework. Sorry, we didn't get enough time to get through